Hi, I'm Aditya Krishna, and this is the JDCIL Technology Law Podcast. On today's show, we'll be talking to Mr. Anirudh Burman on India's proposed data protection bill. In specific, we'll be analyzing whether the proposed legislation would really protect privacy and promote growth. Now, Mr. Anirudh Burman is an associate research director and fellow at Carnegie India. He works on key issues relating to public institutions, public administration, the administrative and regulatory state, and state capacity. He's also worked extensively on financial regulation and regulatory governance. In the past, he's worked for the Center for Policy Research in Delhi, Amarchand Mangaldas in Mumbai, and PRS Legislative Research in New Delhi. He's a graduate from NUJS, Kolkata, and went on to obtain his master's from Harvard in 2012. Good evening, sir. It's a pleasure to have you here today on today's show.
Good evening. Thank you for having me here.
So I thought we could just start off by understanding a basic understanding of the jurisprudential basis of privacy in India.
Right. So privacy jurisprudence goes back a long way. It started in India in the early parts of independent India. And there's been a lot of ambiguity on whether there's a definitive constitutional right to privacy over the years. And there was a conclusive answer in the Puttaswamy judgment, but prior to that, there have been cases in which the Supreme Court has decided that there is a constitutional basis for a right to privacy, and there have been other cases in which the court has actually denied this right. Now, what's interesting is this debate has always taken place in the context of a specific dispute or the specific allegation of a violation of privacy rights. The interesting bit about Puttaswamy was that there was no specific dispute in the Puttaswamy judgment itself. As you know, there was a 5-judge bench that was hearing a dispute about the constitutionality of Aadhaar. And that bench, in trying to decide that case, they actually constituted a larger 9-judge bench to decide on a abstract question of law. There was no actual legal dispute in front of that 9-judge bench. And that's the interesting departure from the way the constitutional jurisprudence has developed. It's not just in the fact that privacy law was given a definitive shape in Puttaswamy. It's the procedural mechanism through which that judgment came about. That in itself has been it's been quite problematic from my point of view, and we can discuss that more later. But coming back to the main idea of how jurisprudential development has taken place, there have been these twists and turns where, for example, in the case of Khadak Singh as a state of MP, the Supreme Court decided that there was no right to privacy, but in some other cases, they have held that there have been rights of privacy that are capable of being protected by courts and so on. Right? Over the years, what has happened is that digitization, the growth of social welfare mechanisms, databases with governments, these have all contributed to a growing demand for privacy because we have a lot more information that is available online. Citizens and residents in India are also transacting much more online. And this has happened largely over the last decade or so. Information communication has become much more relevant to our everyday life. And that's also increased the stakes for issues like privacy, confidentiality, online security, and so on. So the developments or the legal challenges that we are seeing in privacy law jurisprudence are also responding to the privacy market, the growth of an online economy, and so on. And a lot of this actually then came to a head during the Puttaswamy cases.
So would you say that, in the Puttaswamy case, our understanding of privacy changed as well from its, its more formative understanding of it being a response to a harm to now becoming something that's more of a right itself? And what changes do you think that made in India's, legal landscape?
Well, there was a narrow question asked, which is there a right to privacy under the Constitution? And if so, what are its contours? Right? And the judgment not only did that, it also went and explained other things that it need not necessarily have. So from my point of view, there are two big problems. One, the judgment was a judgment without context. and do even without context, it exceeded the brief that was given to it. So it does say that there is a right to privacy, and it goes into great lengths to explain the nature and scope of the right to privacy. Informational privacy is a part of it, right? But one significant thing that it does, and that will have a long and lasting effect on not just jurisprudence, but also the way the Indian state interacts with individuals, with citizens, is the way it has talked about how the state can actually regulate privacy and what are the tests courts should use to see with state regulation of privacy or state interference in privacy is legitimate or not. And my argument is that in doing so, it's actually strengthened state power significantly, mainly because it's basically said there is a strict scrutiny standard. Right? Your examination, the court's examination, will be based on whether there is a legitimate use, the use is proportionate to the objective, and so on. Right? And what that basically means that you can only look at state intrusion of privacy on the grounds of legitimacy and proportionality. It does not actually give you the license or give courts the license to look at privacy from other grounds. For example, what is the freedom interest being harmed? So if you look at a lot of privacy jurisprudence in the US, for example, you look at the legitimacy of laws restricting contraception, Griswold versus Connecticut. The court's judgment in the US Supreme Court's judgment in that case actually hinged around the issue of whether a liberty interest was being harmed by state intrusion. So the violation of privacy was actually linked to a liberty interest, not just about whether the state intervention was proportional. You imagine if the use of contraception is actually looked at in India from the point of view of legitimacy and proportionality. It will have a completely different outcome. So those are some big changes that I think are going to be problematic in the long run.
I get that. Completely changes the dimension in which we look at privacy as well. It changes the way we regulate it as well. That's quite insightful. So would you say that there are any changes, or rather with the PDP bill coming in, and how do you think the PDP bill ties in with this jurisprudence that is now created post-Puttaswamy?
Yeah, so the PDP bill and the demand for the bill came from the same quarters as the demand for a relook at the design of Aadhaar. And the privacy debate was basically coalescing around these two issues. One, we don't have an overarching privacy law in India. And two, there is a problem with the way Aadhaar is designed and it's working. Right? And the other was, of course, the use of state power for surveillance and so on, which ironically enough hasn't gone anywhere. It's still stuck in the same place that it was. But we've made progress on these two other issues. And the demand for the PDP bill led to the government constituting this personal data Justice Sri Krishna committee to look at the idea of a privacy legislation. They worked for about a year and a half or two to come out with a comprehensive report. They proposed a draft PDP bill. The government then undertook a series of consultations, after which it came out with its own version of the PDP bill, which is currently in Parliament. And so that was the process that broadly went on before this bill came into Parliament.
So with respect to this PDP bill, are there any salient features you feel a listener should be aware of? And you can look at it both from the perspective of just important features of the PDP bill, as well as differences with the PDP bill and GDPR, or even differences with the PDP bill as it stands now compared to what the committee had sort of recommended.
Yeah, so there are some differences, but broadly the commonalities outweigh the differences in the case of the PDP bill. If you look at the GDPR, which is now the operative EU legislation that works in 27 EU member countries, that the GDPR, a lot of the other international frameworks, a lot of other domestic legislation in other countries, the California privacy legislation that affects all of Silicon Valley, for example, has broadly similar principles and ideas. And the broad ideas are about protecting the use of data through the idea of something called user consent, which is data should not be collected without the user's knowledge. Right? Some limitations on how data that is collected can be used and processed. Right? And that basically revolves around the idea of saying the data should not be stored more than necessary. You should not be collecting more data than required. Users should have a right to know what data is being collected, why is it being used, right? And for what it's being used. The data should be deleted once it has been used or once the purpose has been satisfied. And users should have some basic rights about whether data should be. So for example, if incorrect data is collected or your name and your profile information is incorrect, users should have the right to correct it and so on. And in addition to that, there are obligations on companies that collect data with regard to how they process that data, with regard to the security standards that they adopt in order to keep that data safe, who they can share that data with. In some cases, they're required to audit the safety and security of their entire databases, the ecosystem, and they're required to do some kind of impact assessment on exactly how the use of this data is going to affect individuals, affect the market, and so on. The idea is that there is this large preventive list of obligations on individuals, businesses that collect data, and that imposing these compliances at a preventive level will reduce the risk of privacy harms that are going to be caused to individuals. So that's the broad structure, and in order to implement it, a lot of jurisdictions create regulators who are going to actually monitor compliance with this. So in the EU, most countries already had data protection authorities before the GDPR was promulgated, and the ones who did not created new DPAs after the GDPR was implemented. The Indian bill similarly proposes to create a data protection authority who's going to be in charge of implementing the provisions of the bill, making sure that it sets some standards for implementing a lot of the security standards, how notice is given about data being collected, how consent is taken from users, and so on. So that's broadly the architecture of what a lot of this legislation.
If I could, I'd just like to take you to your first aspect about consent. And this is something that you've critiqued at length. And I was just wanting to understand, why do you feel that, there's an issue with consent being the cornerstone of data protection in India?
Yeah, the issue is not so much about consent being important. The issue is whether consent is useful for having as a cornerstone for regulation. So nobody disagrees with the idea that your data should not be collected with your consent. And I think the new version of the bill that's currently in Parliament is an improvement from the JSK committee version in that sense, because it reduces the importance of consent in the sense that it treats consent as a safe harbor. So if you've taken consent, you can, some of the limitations that are available for processing, they go away. So, and the problem with the earlier version of the bill and GDPR and other legislation like that is that consent is no longer meaningful as a cornerstone for regulation. So the idea of using consent as a key device or instrument for privacy regulation came about in the late 60s and the early 70s when digitization in the US and other advanced democracies was just beginning to start. There were very few government bodies and private companies like banks and insurance firms who collected information on a scale large enough that would be a threat to privacy. They all had large databases, but it was also expensive to collect this information and maintain this on servers and so on. Right? So the computing power that was available 50 years ago is almost peanuts, costs peanuts to both buy and use today. Right? So in that context, consent was far more meaningful for thinking about regulation because users could understand who was collecting their data, what that data was being collected for, and where it was stored. There were such few entities and such few users for the collection of data. So the meaningfulness of that idea has just completely gone today, right? Because you are consenting to data collection on a scale every single day that you just do not understand. You're incapable of understanding what all you're consenting to, right? So we've all seen the literature on how users just do not read privacy policies. do not read license agreements, studies that show users spend 6 seconds or 3 seconds reading license agreements before agreeing to terms of services and so on, right? So in that sense, it's become more of a friction than any meaningful device to inform you about collecting your information. Right? So the idea that consent can be a meaningful cornerstone for protecting privacy has become meaningless, or is becoming increasingly meaningless, just because the intensity of online behavior has just changed. It's exponential, and it's growing exponentially every single day. Right? So the idea that you can use that same tool or instrument that was proposed in a specific time and context, given a particular scale of technological development, right, 50 years later, right, does not seem to be as useful as one would think. And yet we are still thinking about consent the same way. So that's a problem.
How would you suggest that we go ahead with this? Would that mean that we keep the consent requirements as impositive as it is right now, or do we decrease it and supplement it with something else?
So one is the idea that we should continue to understand and identify with the idea of consent as a basic prerequisite, right? So as with all things in life, anything done without your consent is borderline problematic. And ideally, your information should not be collected without your consent unless there are specific situations that mandate it or that require it. Right? And there are very few. You can have a pandemic, you can have a security emergency, things like those. Other than that, your information should be collected after you are informed. Right? But that should not necessarily be the fulcrum of regulation. The fulcrum of regulation should be around what harms individuals, and we can discuss what harms we should worry about as a society. And that's one big problem with the discourse we've had in India so far, which is that we've not had a good discussion of what are those 10, 12, 15 harms that we should worry about. If you look at the PDP bill, harms are defined very, very broadly. Right? There are things like evaluative use of data. Evaluative use of data occurs 100 different times a day regarding any individual's data. Right? Not all of that is necessarily harmful. Right? Some of it is useful. It can be used to give you more contextual information about your preferences. Right? It can be used to give you discounts that you would otherwise not see. It can be used to show you products that you would otherwise not see online. Right? So it's not all, everything is not harmful. But the way the idea of harm has been defined in the bill needs to be thought through much more carefully, and we need a greater discussion on what are those privacy harms. Right?
So in the context of harms, when you're speaking about these specific harms, doesn't it become a little too hard and make the bill a bit rigid if you're supposed to, conceptualize and understand what are the things that are sort of controlled in such a sense? Because the way I've seen, consent requirements being used, and if you look at, various, cases across the EU, the consent requirements are usually helpful where a consumer did not know about it, but then it's later useful to protect their rights in some manner or the other. And so I'm just wondering, how does this harm balance out the pros that, a heavy consent requirement would help in a court of law?
So the idea is not so much that consent should not be something that litigants go to court for. The idea is, if you are interested in protecting privacy, what is the instrument that you use that is going to be most useful and most effective in trying to protect user privacy? Right? Does the idea of consent really protect privacy? All you see in post GDPR implementation are notifications saying your cookies are being stored in a particular manner. Right? Is that greater privacy protection for you and me? I don't think so. Do I have better information about how my data is being used? Not really. So it's not so much about whether consent should not be taken and consent should not be given as a right. Consent, and I see a basic contractual privacy stipulation. If you collect my data without my information, there's something wrong, right? There's no contract between you and me, right? And if you are using that in a way that I would not have allowed, right, then there is a problem, right? There is a violation of some legal principle and some legal right, right? Whether that translates into a mechanism for solving a privacy problem is a different issue. Right? And that's why I'm arguing that we should think about privacy related harms as being more instrumental and as being the cornerstone on which you think about privacy regulation, right? Not necessarily consent. You could suffer harm even after having consented to a particular use. Right?
True.
So
that makes sense.
consent-related provisions wouldn't actually prevent you from suffering harm in many cases. So rather than having this preventive obligation around consent and notice, let's focus more pragmatically on the actual harms that you're going to suffer. Right? Are you going to suffer, for example, unsolicited phone calls? Is that what you're worried about? Are you going to be at increased risk of predatory behavior from individuals as a risk of data leakage or data theft? Right? Is your financial security going to be compromised because your data was stored in a way that it shouldn't have been? Right? So I would rather worry about the downstream harms and then work my way upstream to protecting what's really needed, what's really important in order to prevent those harms from occurring. Right? Rather than have a large bouquet of preventive obligations that I'm going to impose on an entire economy that's trying to grow into prosperity.
I think that's a good segue to get into your second criticism about the aspect of limitations that are sort of imposed, these preventive obligations that are imposed. And I just want to understand, what is your view on them? Do they have an effect on our economy? And, in that regard.
Yeah, so the limitations that are imposed have been, first of all, they've been diluted significantly in the new version of the bill. And the new version of the bill actually takes into account the idea that if you've taken consent, a lot of the limitations on processing that were there in the earlier version of the bill no longer operate. Right? So in that sense, there's an improvement in how the government policymakers are thinking about the idea of using consent as a safe harbor. What was there earlier was more problematic because there was almost a prohibition on certain kinds of processing. Right? And the problem with that is that the use of data and innovations surrounding data are so dynamic, right, that the market structure that we see today might not exist 10 years from now. Right? And in that sense, the strict prohibitions in the earlier version of the bill really had the potential to inhibit innovation, right? Because they would have basically ensured that all innovation occurs within a particular straitjacket, which is problematic because we don't even know the direction in which innovation is going to take place. Right? Businesses that did not exist 10 years ago, 20 years ago are behemoths today, are trillion-dollar companies today. Right? We don't know if something similar could happen in the next 10 years. And we don't, given our state of development where innovation and productivity really matters to us, right? We are a $2,000 per capita economy. We are talking about, when we compare privacy legislation, the US is a $40,000 per capita economy. China is $15,000 per capita, right? So if you want to grow to that size, right, you really cannot afford to inhibit innovation, productivity enhancing technologies by keeping them in a straitjacket, especially when we don't understand what direction that innovation is going to take. Right? The bulk of our small enterprises, we only have, a very small proportion of our enterprises are actually large enterprises. 90% of our enterprises are actually pretty small. The bulk of our economy is informal. Technology, use of data, these are actually ways that you can grow quickly and cheaply without having to go through a lot of licensing, a lot of red tape, a lot of bureaucracy. You don't need 50 different approvals from government to create a tech-oriented startup. Right? So this is giving an avenue to entrepreneurs in both large cities but also tier 2, tier 3 cities. And if you start imposing limitations that inhibit innovation, that inhibit productivity, it's going to affect them. So these are going to be much more costly for us compared to jurisdictions that are already rich and prosperous.
I think that's a very interesting point you brought up, the way our Indian structure is sort of different, where we have more smaller and medium-sized enterprises, and about how, when we are trying to develop our nation, simultaneously, inadvertently, we are stifling development through the same manner. Now, like you did speak about innovative technologies and the development of the tech industry in India, two things that are literally on everyone's mind right now is blockchain and AI algorithms. And since there has been significant developments in India as well in these fields, I was wondering, is there any effect that the PDP bill would have on these industries and people engaging in these industries?
Yeah, so the short answer is there could be a potential impact. And again, the idea is that if you straitjacket different forms of innovation, you don't know what you're going to inhibit, and that could potentially be costly, right? It's a counterfactual. It's hard to demonstrate by way of evidence because once you impose a regulation, you don't know what might have come up. It's the story of the first 30, 40 years of India's economic policy, right? We had so much bureaucracy and red tapeism, we didn't know what businesses could have come up during that time. It's only when we de-licensed and deregulated, we saw the entrepreneurial zeal within India. So it's basically the same parallel, and there are different forms of blockchain that could potentially be affected if we have a lot of use limitations, if we the PDP bill's way of imposing accountability. For example, there are decentralized blockchains that are permissionless blockchains that are actually not owned by a specific company or a firm or an individual. Right? And these could be useful in different ways. For example, in creating timestamps or proofs of authenticity, right? That don't need to be paid for or compromised by the control of one individual or one company or one firm. Right? But because the bill imposes accountability on the person collecting data, you cannot have a truly decentralized blockchain because there is no one person or company who is collecting data. So certain forms of business practices would just cease to exist if you went down this path of imposing accountability and requirements. Similarly, AI is algorithmic processing, which people don't actually understand very well, at least in some cases. For example, people don't know what considerations algorithms use to evaluate data in many cases, right? And in a lot of cases, they don't understand what are the different considerations the algorithm is using, how much weightage is it giving, right? So in that context, how do you hold someone accountable for the end result or the outcome? Right? So we've seen cases where the outputs of machine learning have been clearly discriminatory. Right? There have been a couple of cases where they've observed a racial bias or gender bias in the outcomes. Right? One way to see that is that it's basically biased data that's input into the machine learning process, and therefore the output is biased. Right? The other is that no, we actually don't know anything about how the algorithm is using this data. Right? And in that case, you don't actually know how to hold the person accountable. Right? So there are going to be these problems. Not all of them are insurmountable, and as the market develops more and as innovation keeps taking place, some of these issues they'll generate a clearer understanding. But these are some things that need to be thought about. And the larger point I'm trying to make is that we should not assume that there is no trade-off. Right? There will always be a trade-off when we are imposing large-scale legal compliances under the name of privacy, security, confidentiality, whatever it is. It might be a noble intention, but it's not a costless imposition. At the end of the day, everything translates into someone having to spend additional money on creating better infrastructure, a more safe database, or not being able to develop a particular line of business or a particular kind of technology. And those are the trade-offs that we need to keep in mind when we think about legislation like this.
That actually makes sense. I do see your perspective in this sense that, it would curtail certain businesses from developing. Apart from that, the black box effect, like you were describing, of AI is something that I think every legal regulator is sort of struggling with at this point. And, it would completely change the way we sort of look at how we're even understanding what's happening. So I do get that aspect. It's quite interesting. Apart from that, I just want to know whether, there is a way you see forward from here. How do we move forward, just having analyzed these issues?
So I would think we should be pragmatic about it. On the one hand, we do see a global framework on, or at least the broad contours of what constitutes privacy regulation coming up in different parts of the world. And whether I like it or not, there are some components of it that are now in use in most parts of the world, right? So the idea of consent, the idea of informational privacy, the idea of preventive compliance requirements around protecting privacy is something that's here to stay. It's being pushed pretty vociferously by some countries and regions, but a lot of jurisdictions around the world are coalescing around these ideas. So we should actually try to harmonize with this, because we are also a country that exports a lot of IT services. We also export a lot of technological know-how. We are, in some sense, a hub of outsourcing that would potentially lose out if we actually did not harmonize with the rest of the world, right? So we do need to be pragmatic in how we think about the larger structure of privacy legislation. At the same time, we should do that in a way that makes sense for us, right? So we should be taking hard calls on what we can afford at our level of development, right? So some kinds of requirements like data impact requirements, requirements on small and medium enterprises, right? Maybe we should not be focusing on enforcing them right now. And we should allow at least our businesses who are using data to grow a little bit before the scale and the threat of privacy related harms become significant. Just by way of context, China only passed its privacy legislation last week. And this is after they've already developed giants who control large swaths of the digital ecosystem in their country. Right? So I'm not making an argument for going the China way, but we should at least be thinking of being pragmatic given our own context. We should think about how to maximize the gains to our economy while at the same time protecting privacy where it matters. We should be much more harm focused. We should be having a deeper understanding of where are the failures in the privacy market. Right? Who are the most vulnerable users? What are the most high risk sectors? Right? And we should try and focus privacy related enforcement in those areas. For the rest, we should actually try and keep compliance burdens minimal for as long as possible.
I remember you argued a similar point in another piece of yours, which I will attach for the listeners to peruse through, where you explained about how GDPR is contextually different and the economic benefits are very different from, in Indian context, how PDP applies. And while you were talking about this, I was just reminded about that and about how such a study of the economics of how it all plays out is extremely important, especially in a context of a country that's developing. If I could just move back to an earlier point you had stated, so I just want to understand when we're moving to this from a positive list to a negative list approach, as you'd stated, would that require a more principal understanding, or would that be a more a specific understanding of specific things of harms that are not to be allowed in a digital economy like ours?
Yeah, it's a good question. And it's a problematic issue because the privacy rights, at least in information technology, are thought of is sector agnostic. Right? So you think of digital privacy as a cross-sectoral thing. Right? And there are some exceptions made where you think about sensitive personal data and critical personal data, where, for example, financial information or health-related information is thought of as much more important. But for the large part, the imposition of privacy obligations is sector agnostic. Right? And that in itself is a problem in some ways. And this is something regulators will have to think much harder about, because there are sectors that are more vulnerable or more high risk because of the kind of information they hold and collect. And also because of the systemic nature of that sector, right? So for example, if banking related information were compromised on a large scale, it's not just the individual privacy issue, right? It's also a national security risk, right? So there are going to be sectors like this that are going to be more critical from the point of view of privacy enforcement. Having said that, there is a difference between privacy and security. So we do need regulators like BA to make that distinction carefully in their mind. Some elements of privacy can be protected by having greater security, right? Whereas some elements of privacy can also be protected just by the user being more careful. Right? It's not all a question of what security technology or what security systems companies are imposing. If users are more careful and think more deliberatively about sharing their data, that is the first level of privacy protection. So there will be these contextual differences. One of the suggestions that came, and it was also something that I agreed with for a large part, which is to have sectoral enforcement of this PDP bill. So let the RBI do data protection under the PDP bill, but in its own sector. Let SEBI do data protection for the securities market. Let TRAI do privacy protection for the telecom market. And the idea is first that the regulator knows the specific context and working of their own sector much better than a standalone DPA. And second, the size of the regulated market is smaller. The regulated entities are already used to reporting to the RBI or the SEBI or TRAI or whoever it is. So the way that it's going to operate is going to be contextual. It's going to be much more specific to that particular area and that particular field. Therefore, it might actually be more pragmatic than having this large sector agnostic regulator who's going to regulate all parts of the Indian economy.
That makes sense as well, like taking the time to make it more specific. I mean, this would take a longer period of time, but at least it wouldn't affect the economy in the short scale and long scale as well. Just before that, another aspect that you had spoken about just now was about the DPA powers. And I was thinking that we could move into the aspect of the administrative, law implications of these regulations. So at first, I just wanted to understand why you argue that the PDP bill tends to dilute privacy and amplify the powers of the state.
Yeah, it's pretty clear. I mean, we did not have a regulator for information storage and collection practices. Right? Let's think about DPA in that sense rather than a privacy regulator. Right? Its main job is to regulate the way in which information is stored and collected. Right? So in a sense, we are creating a regulator who is going to supervise how every company in the country collects information and supervise their storage of information. And in order to make sure that they are doing a good job, it will be able to inspect all the information collected. That's a clear dilution of privacy. You are basically giving the state the complete license to look into information using coercive power, right, under the garb or the veneer of protecting individual privacy. Right? So this is not to say that the officials of the DPA will be, malign, or they'll have the wrong intentions, or that they'll start misusing their powers. No, the point is that even the legitimate exercise of this power is a violation of privacy, because you're giving the state coercive power to look into the data collected by every company, every business, every data fiduciary in the Indian economy. How is that not a violation of privacy? So if privacy, forget all the problems around surveillance related issues, the exemptions that are given to government agencies under the bill, right? Those are problematic. Those are hugely problematic. But the very creation of the DPA means that you're creating a behemoth, a regulatory agency, which is going to look at data collection across the Indian economy. It will be able to inspect, impose penalties, call for reports, call for information from any entity that is basically not exempt or basically not collecting data manually, right? Which is increasingly more and more businesses around the country. Right? And we are giving the state the legitimate coercive power to do this. This is, by its very definition and its conception, a violation of the classical idea of a privacy violation or a threat to privacy is also to protect you from the legitimate role of the state. Right? There are many, many ways in which the state acts which are, for all practical purposes, legitimate, but they constitute privacy violations. And courts around the world have basically said Even if you've acted legitimately, you are violating privacy. And that's the same idea, that if you are creating a huge regulatory agency, and remember, this is not context specific, this is not to prevent you from a specific harm, right? It's a large preventive framework that's being put in place. Although the new bill does make it better, but by the larger design or the conception of it, you are creating this large regulator that's going to have the power to look into information, look into a firm's information collection practices, and that's problematic.
And how would you say this changes with, let's say the pandemic and how a surveillance culture sort of developed over the course of this year? It changes the way the state's power, surveillance, and privacy even, works out. So I was just wondering to understand, how would you think this would play and interplay with the new bill and the way our, privacy landscape is playing out right now?
Yeah, so I think some of the debate is missing the larger picture, which is we had a pandemic that was threatening millions of lives. And in that context, I think most people are willing to surrender a little bit of their privacy, right? I mean, people are willing to surrender their right to run their shops and run their businesses and go to work and work from home and so on. Right? So if you're willing to sacrifice all of that, I think people are also willing to trade off a little bit of their privacy. Privacy is not the most important value at some or some untouchable value, regardless of the consequence. Right? So we do have to keep that in mind when we think about what's really happened in the last year or so. So what's really happened is that there have been different ways in which states have become more intrusive from the larger purpose or perspective of trying to combat COVID. So there are laws like the Epidemic Diseases Act, the NDMA, the Disaster Management Act, that gives the state the power in these kinds of situations to do contact tracing, to be more intrusive than they normally would be. And these are pre-existing powers. It's not that new laws were drafted as soon as COVID occurred. Right? And to implement a lot of these powers, there were new apps that were developed. People had a problem with the privacy policy and the kinds of protections it accorded. Now, my opinion on that is that given the standards of privacy protection given by most apps, right, not just Indian government apps, the privacy protections guaranteed in the Arogya Setu app were pretty decent. Right? You could always have problems with the exact language and it being not good enough, but relative to most apps of a similar nature that collect information, it was a pretty decent licensing agreement or a terms of use agreement. Interestingly, if we had the new version of the PDP bill in place, we would not have this level of protection, because this bill basically says that you can waive off notice and consent requirements, and you can waive off a lot of these limitations on storage and processing in times of emergency. Right? So ironically enough, we have better privacy protection when there is no privacy legislation, right, than we would if we did actually have the privacy bill, right, in force. Which is, I mean, it also goes to say that we should not think about laws equals privacy. The market can also supply privacy. Government can also supply privacy, right? And it does not always need a law or a right. It does not need the court to declare that there's a right for there to be rights. And just the fact that the court has declared rights does not mean you are suddenly more protected. Right?
I think
So
that's a very
something
interesting. Yeah. I think it's a very interesting thought you brought up, and quite ironic as well that the new laws can have lesser protection than what we have right now. Just one more question before I move on to the other aspect is that, do you think there are any structural changes that are going to happen in our society, considering, let's look at during the pandemic, and correct me if I'm wrong, but if I remember rightly, Andhra Pradesh had introduced this new facial recognition cameras to sort of look at whether people are wearing masks and not, or not. And seeing that it was introduced as a pandemic, sort of safeguard measure, but the fact that it might even spill over into normal times as well. Do you think that the power of the state or the strength of the state in this regard is changing, the dynamic is changing?
It is changing a little bit, but I think it's not something that cannot be countered or counteracted. So one test of whether the power is permanent or not is whether you have a new law in force and whether that new law is being implemented. Right? And we've seen this across history during World War I, World War II, the Great Depression, right? All these kinds of calamities and emergencies. New laws that strengthened state power, and the increase in state power was permanent because the new laws were in force. It was not because of temporary executive measures. Right? So, for example, Arogya Setu will become redundant in another year if COVID goes away. Right? Arogya Setu is not created under a law and mandated and so on and so forth. Right? So even if someone keeps saying download Arogya Setu, no one will do it because no one cares anymore. Some other legislative measure that mandates data collection, right, would be far more permanent. Right? So for example, the provisions in the PDP bill that say that surveillance agencies don't need to meet any requirement. Right? Those are permanent requirements. Those are permanent legal provisions. They're going to be there. Right? So that is a kind of a dilution of accountability or an increase in state power, however you look at it. Right? It's two sides of the same coin. That's going to be permanent. Right? And it's going to be permanent because a law is actually going to make that concrete and permanent unless you change the law itself.
That's actually quite interesting. And I think another way to look at it is like the Aadhaar, which comes under an act, which is staying on, while Arogya Setu, which might just go off after the pandemic.
Yeah.
If I can just get back to a previous point that you'd brought up about the DPAs. So earlier you'd referred to how the PDP bill is not sector specific and how it's sector agnostic. And I just want to understand, how does this affect the DPA's power, or rather the capability to regulate data protection landscape?
Well, the first thing to understand is India anyway fares poorly on regulatory capacity issues. So if you look at global rankings that try to measure regulatory capacity, we are somewhere near the bottom or in the lower half. Right? So, and this is where we have regulators who have already functioned in different sectors of the Indian economy for a certain period of time. The RBI is around for close to 100 years now. It's around for 85, 90 years. SEBI has been around for almost 30 years, TRI for 15 years, and so on. Right? Many other regulators have been around. And we still do not measure very highly in terms of regulatory capacity. Right? And keep in mind that these are regulators who regulate specific sectors, so they have the opportunity to hire and train and develop expertise in specific sectors, right? There are very few regulators who regulate across sectors. So the Competition Commission is one such regulator. But even for the Competition Commission, how it works is that people bring complaints and occasionally the CCI takes suo motu notice. So it's not a system where the CCI is writing regulations on a daily basis, which requires a very different level of expertise, the kind you see in SEBI or RBI and TRI and so on. Right? And now you have the DPA, which is basically going to be cross-sectoral. It's going to regulate data with all its contextual differences, specificities, large-scale enterprises, small-scale enterprises, tech firms to small car dealerships, hospital chains to small dispensaries, right? Everything within the Indian economy that's basically processing data in any way will have to be regulated by the DPA. And the DPA will have to build expertise to do all of that. And if you look at the way the online economy works, the intensity of transactions it's enormous. It's increasing day by day. It's exponential almost. So the amount of data that is available online and that's generated, first it's humongous, but it's also increasing at a humongous scale. Right? So the DPA will have to develop the expertise to not just regulate the way a SEBI or RBI does, but it will have to do it for different uses, contexts, and types of uses of data by different kinds of firms across the entire economy. And that's a huge challenge. Right? So the idea that we can have a effective DPA just because we'll give it great IT systems and have a very smart chairperson and board I don't think that's going to be adequate because it's not something 5 smart people can solve. Right? With the best of intentions, with the best of resources, it's still going to be a very, very difficult job. That will create two kinds of problems. We can either under-regulate privacy, right? In which sense, privacy regulation becomes meaningless because what's the point? Or you will over-regulate it because you want to show that you're doing something, right? You will impose these draconian standards, or you will go after 5 big tech firms and impose large penalties and try to show that you are really doing your job with a lot of zeal and enthusiasm, which will be counterproductive. It might scare away people, it might inhibit other kinds of activity. So there is a real problem in how we think about building this capacity for a DPA in a context like India. And that's why we need to be far more pragmatic. We need to think about what are the actual priorities when it comes to protecting individual privacy in India.
That's actually quite interesting. In another sense, like, looking at it from the perspective, I've seen similar arguments also being made for why, judges in the Supreme Court should not use aspects of foreign law. Because, and I think this was an argument Tarnab Khaitan had made about not being able to be an expert in both domestic as well as foreign law. And just bringing it back to what you've argued here as well, it comes down to an aspect of, practicality. You cannot expect a person to be, as well versed in every sector as well as the privacy sector as well. And I'm just thinking of it now, like you'd need a massive, regulatory board as well to have an expertise that span over all the sectors in India. So that's actually quite interesting.
The way we think about law, and we think writing a great law is equivalent to getting great outcomes, and I think that's a problem because we should not be fetishizing legislation for the heck of it. Right? I mean, great legislation can work if you take into account contextual realities and if you think about how to implement them properly. But just having a law that reads like a vision statement of what you want will not necessarily give you the right outcomes.
So just before we end, I thought we could also understand the various administrative law concerns that come from the PDP Bill's framework and understand, whether there are any checks and balances on the DP and the state and what should we be concerned about.
I think the big problem is that the DPA needs a better mechanism in terms of the composition of the board. It needs much more detailed and specific requirements for the qualifications of board members, and it needs some independent members who are not full-time board members, because that independence of vision or that independence from your daily job helps you first give a different perspective to the agency, but also helps you ask difficult questions. And if you don't do that, then there is groupthink, there is a dilution of accountability. You are all committed to, or you face the risk of being committed to solving the wrong problem and not realizing what's out there, right? So you need independent members on the board who are not going to work full time as part of the DPA and are part time. And this is there in almost every other regulator. And we need to tighten up the qualifications for the selections of the members a little bit more. So those are the two big concerns. Other than that, we also need a mechanism where at least the wing of the DPA that's going to impose penalties on regulated entities, there has to be some functional separation from the rest of the agency. Right? So the part of the DPA that's imposing penalties cannot be the same one that's doing the investigation. Right? Now, regulators are inherently problematic because you merge different parts of the state. Right? So there's a regulation making or legislative function, which is usually done by parliament, right, or parliamentary bodies. There is an executive function which is supposed to be done by government or governmental bodies, right, where you collect information, make sure that the monitoring is being done properly, and so on. And then there is the judicial function where you actually take a decision as to whether someone violated a law or violated a regulation, and then you impose penalties. Right? And for very good reasons, there is a theory of separation of law, separation of powers, because you don't want the executive and the judicial function to be done by the same person. And this is a problem we see in other regulators in India as well, right? So you do need some functional separation of the wing that is going to take that quasi-judicial decision and the wing that's going to actually do the investigation and the prosecution. you can't have the prosecution also be the judge, right? So you need some internal separation of powers within that. And the other big issue that's going to be fairly critical for the DPA is going to be how it frames regulations, how consultative is the process. If you suddenly have a regulation out of the blue, you are not going to be able to think about how to make decisions over the medium term, right? So the way most advanced jurisdictions do it, and some Indian regulators are getting better at doing it, is to first release a draft of what you're proposing to do, write a document explaining what it is that this regulation is trying to do, why it's important, what is it, what outcomes do you foresee out of it, do as many stakeholder consultations as possible, do a cost benefit analysis, explain that even if there are some costs, how are the benefits going to stack up in comparison to the costs, right? Then take comments on all of this and then come out with the final regulation. And most regulators in India are not doing it properly, even though if some of them have started. But in the DPS context, it's going to be even more difficult for the reasons we discussed earlier, which is the speed of innovation is so dynamic. It's going to be almost impossible for any regulator to know beforehand what is going to be the likely impact of the regulation, right? And it becomes even more important in that context to have as much consultation, try to factor in as many different considerations as possible. So these are some of the big administrative law issues that need to be fixed.
I think that's a fear that every law student interning and lawyer practicing has as well, of not understanding the regulatory framework that's in the country. And I mean, yeah, I get that entirely. Apart from that, any other aspect that you think, with regard to the powers of the state, is there a checks and balance mechanism under the act, or what measures are there in place to protect the normal users and stuff?
So a lot of the standard checks and balances that are there for most regulators are there, in the sense that the way the DPA will, for example, use finances from the Consolidated Fund of India, there is a reporting mechanism. The DPA will have to present an annual report to Parliament. Rules made by the DPA and the central government will have to be laid before Parliament. There is a fixed term of appointment and service for board members and the chairperson, so they're protected from political interference and so on. So a lot of these standard checks and balances are there, and these are generally there for most regulators in India. What we need to do is to improve on some of the finer aspects that I'm talking about, which actually create a lot of uncertainty in the Indian market or for business, right? So as far as the problems around independent decision making, political interference, political accountability, I think the bill is as robust as most other regulatory laws. But as far as being cognizant of issues of innovation, market certainty, those are issues that need to be improved significantly.
Thank you so much. So just to conclude, so how would you say, one should look at or understand how we can have a more privacy-oriented data protection regime in India? What would you suggest that some of the changes are, and how can a normal person look at the bill to better understand these critiques?
So I think some of the things that are there in the current version of the bill are positive indicators that there is some serious consideration being given to a more pragmatic approach. And I think the idea of using consent as a safe harbor, using the idea of harm in mandating or in requiring the DPA to make regulations is something that's already there, and it's a good thing because it focuses the DPA more towards the idea of harm than to more vague principles. I think some more rationalization, the compliances that are there under the DPA would be much more helpful also. So for example, if there is a clear indicator of the kinds of MSMEs or small businesses which will be exempt from DPA regulation, at least for a period of time, so that you at least give them time to grow and to start complying and so on. That would be something that's good in addition.
Thank you so much, Mr. Burman. This was extremely insightful and novel way of looking at the PDP bill. Thank you everyone for joining in. This was the JDCIL Technology Law Podcast. If you'd like to get in contact with us, you can email us at the email ID provided below. Further, all of Mr. Burman's pieces referred to in this podcast have been linked on our website as well as on streaming platforms. Thank you. and we hope to have you again.